And Taylor is here to represent and support the commission's decision.
Okay.
Okay. Good. Okay. We'll move forward.
Just need a moment to connect the monitors. I'll start with just a bit of an overview of the conditional use. Just provide some context.
And they got asked what the procedure will be tonight, whether the appellant will be going first, whether we will have any rebuttal, just what the procedure will be, or whether the planning department will be presenting.
Is there a protocol in meetings as to who goes first?
I don't think so. Doesn't state whether
There's-
starts first.
There's not a specific requirement. It's as the board might direct. If you want direction from council on that, I would ask Lisa. But what has occurred in the past, not that that's always the best, but what has occurred in the past is often the staff will give a report, and the appellant is given due time to address their concerns. You can do it either way.
Okay.
And then typically questions are taken as they come up by the board for clarification.
That sounds, I'd, with the rest of the board, I'd like to see what the staff has to say, but I'm also very sensitive to allowing time for everyone to speak.
Okay.
Is council okay with that approach?
That's fine with me.
Okay.
Okay, so what you're looking at here are slides from the conditional use permit review. I'll just provide some context. Here's the highlighted property, just over 20 acres east of the Smithfield boundary. This is an area that there's some vacant property. It's also developing and homes and development approaching that boundary, that east boundary of Smithfield.
Is that from all sides, or is that just coming on the front of it?
Thank you. The west side, and then the surrounding yellow area is vacant or low-density, single-family residential and forest areas. But you're seeing the A10 zoning there on kind of the foothill bench and bench areas.
Could you, what does the A10 mean?
That is the agricultural residential zone in the county that allows for a density of 1 unit per 10 acres.
Okay, thank you.
And other uses. And so that kind of leads to this next slide, which shows that allowed in the A10 zone is a recreational facility. And this is defined as an indoor or outdoor place that is designed and equipped for the conduct of sports and leisure, time activities, that is operated as a business. I'm going to pull a microphone here. And or open to the general public. Recreational uses may include facilities such as a campground, golf course, or ski facility. The definition of a campground in point B is any area with more than 3 campsites that are improved for occupancy, and that can include recreational vehicles. And a key point here is highlighted that the duration of stay is not to exceed a period of 30 days in that recreational category. And then a campsite can be an area used for travel trailer, recreational vehicle, or tent. In this case, the applicant was focused on RVs and trailers. So here's the site that you may have seen in the attached staff report. And this is showing it highlights that there could be an extension of a phase 2 or 3. The applicant's intent was to start with a phase 1 of 12 pull-through campsites, a phase 2 that could be 26 back-in campsites, and a potential third phase, 27 additional campsites for a maximum potential 65. And this just shows the pull-through and the back-in RV pad sites.
Could we go back to
Trailer.
the previous slide?
Sure.
So is this just showing phase 1?
This, I believe, is showing phase 1 and 2.
1 and 2, okay, that's what I wanted to know.
And there's only one access to it.
That's correct.
And the diagonal lines, are those the power poles?
Yes, that's a power line easement. I should mention that there is a through easement, so other property owners that have easement through could drive through the site and extend onto other properties.
That's on that north side of the property you're referring to?
So there could be vehicle access through sharing the drives, and then what Chris has just highlighted is this 30-foot Hyde Park City water line easement, that the applicant was also supportive of that being a space for potential Bonneville shoreline trail. So there was an attempt to look at any and all easements and make sure that the proposed layout was compatible with those. So this shows a variety of, this is not maybe a complete summary of the final attached rules and proposed in purpose and intent. But I think it's key to note that one of the conditions that we feature in the staff report states that the attached rules, proposed rules, apply, and that the final site plan and use and permit will be in compliance with those rules. And so if anything that may not have been listed as a specific condition is captured by what is in the intent statement of the conditional use, as well as the attached campground rules and the proposal. And these are some of the public comments summarized by category of the concerns, and those were discussed throughout the public review of over the course of the December review and then the follow-up February review. And then the conditions of approval focus on attempting to identify those reasonably anticipated impacts and then to provide reasonable mitigations to those. And there was quite a bit of time and effort applied by the commission to understand those and put it through the reasonable test. And I think what we've highlighted in the staff report is that we could jump to as perhaps a focal point. Welcome, hello. It's good to have you here. There was a focus and concern on whether there would be the opportunity to dump the sewage tanks from the RVs onto the site or to utilize off-site RV facilities for dumping. And we, as staff, did our best to review and understand the details of that. However, after the conditional use permit was approved, the applicant and Bearview Health Department in further investigation found that there were additional rules and state code that apply. And so the potential solution of having a pump truck service the RVs rather than providing an on-site dumping facility. In fact, the rules, the attached rules to the conditional use permit say no on-site dumping, as well as the intent letter. But then following the conditional use permit approval, it was learned that there is a requirement to have both a public water system and on-site dumping, and that either be connected to city public water system or city sewer system, or to provide an on-site separate public water system and separate approved septic system, wastewater system on site. And so I think the applicant has been pursuing a further understanding of how to meet those conditions or those state rules and regulations. And so I just put here in summary that in recognition that those state codes do apply and they supersede any county requirements. And the county code does state that state laws do apply. However, it's not specifically noted in the staff report, the conditional use approval. And so we've identified as staff two potential considerations for the board this evening. And one is that the appeal let's see. The appeal may be denied if the state requirements are applicable in spite of the conflict with the CUP condition. In other words, the conditional use permit upheld, and just moves forward with the understanding that all the conditions apply in the conditional use permit, understanding that state code supersedes the self-imposed restriction that no dumping shall remain on the site, or two, that the CUP may be remanded back to the Planning Commission to address the inconsistency between the conditional use permit condition and the state administrative rules applicable to the RV park sanitation.
I have a question.
Yes?
Does he know that?
Yes,
He's aware of that?
that's correct.
Okay.
So I think that just gets to what we've identified as staff as the kind of the crux issue to be addressed by the board. The appellant team has other concerns that we've addressed throughout our staff report, and I think that we could address those at a later point if given the opportunity to. I think they've now had the opportunity to read our memo, but we feel that this is the key point for the board consideration this evening, and we feel that other concerns and issues addressed that we've adequately addressed in the staff report and the staff memo, and happy to revisit those at a later point.
I get, my only comment is, and I've read through this many times, I try to become educated on it. I don't do this every day like you do. But there's just some certain areas there that I have questions about, and you say this is mainly the thing that we really
Okay.
need to look at tonight.
We can look at the others, and if you'd like to hear from us first, or the,
So let's move forward with what we're doing here, and then
we can come back and address each of those in particular. Might be helpful to hear from the appeal team.
I have one question and it applied at another meeting that we had, but a conditional use permit is effective for how long? Is it a yearly thing? They have to get a yearly, they have to come back in every year?
It's a really good question. So the conditions state, some of the conditions state that certain conditions need to be met before it's recorded, and there's 1 year to record.
Right.
But once recorded, then it stands. It's a use that runs with the land. But the timeframe to,
So there
Finalize the
isn't an
CUP.
end to it?
once the 1 year window is up and those specific site plan issues have been addressed and adequately mitigated and met county and state standards, and then recorded, if within 1 year of the effective date
You're
of the
right.
appeal, then it stands on the property in
Okay.
perpetuity.
Well, there is a caveat to that, and that is if the use is expanded or changed,
Yeah.
then it requires another one. Or if it's
Correct.
abandoned for a period of a year, then,
Then it has to be
then
reapplied
it
for.
automatically
Okay.
It goes back to the
goes
commission
away.
Okay,
to be revoked.
okay.
That would be true if they were, if they didn't meet all the mitigation that was in place continually. Right.
Thank you.
Can I ask you one other question? So you've got two possibilities on the outcome, and to deny the appeal, it's kind of a double, maybe even a triple negative, so I want to make sure I'm following it. To deny the appeal is to uphold the CUP, right?
Correct.
So a possible other outcome would be to grant the appeal, which would deny the CUP, is that not right?
Yeah, and those two items were our staff's recommendation to you,
recommendation,
yep,
right.
essentially.
Yeah, okay.
You can come up with any determination you have. Whatever you feel supported by those facts, you can pursue that.
Yeah, I just,
you're basically saying, no, one and then the other one is that it's recommended they go back to the Planning and Zoning Commission again with this, right?
That's one option that we suggest you consider.
and my point
To
is,
address the issues.
Yep.
sorry. My point is just, that it's appropriate for staff to put the recommendation into it. But I also think it's appropriate to outline, the possible decision points. So while you don't recommend a granting of an upholding of the appeal and a denying of the CUP, I think it's appropriate to have it in the list of options for the board. Does that make sense?
Sure. So this list could be expanded upon, indeed.
But I appreciate the work you put into it and all that. It's not that. This is an issue we've dealt with for many years with different staff.
Okay.
Okay.
Thank you. Members of the board, council, Dr. Whitaker, members of the public. I am speaking for myself today.
Can you please state your name?
Sure. Tom Johnson. I'm a resident of Smithfield, as I have indicated in the prior hearing. I practiced law in New Mexico for approximately 40 years before returning here to Cache County. We have grandchildren here, and this is actually the area that was my great-grandparents came to Cache County in the 1870s. So I'm an outsider, but I'm not. And I appreciate your hearing me today. First of all, I would like to state what should be obvious, but what has not been expressly admitted. What has been stated so far is that the conditional use permit as granted conflicts with state law. Now that's a euphemism. What that really says is that the conditional use permit as granted violates state law, is illegal, and should not have been approved. Call it whatever you will, but it violates state law. In the training that you received tonight, it was noted that state law supersedes county law. In the same sense, federal law supersedes state law. The Constitution of the United States, for example, is the supreme law of the land, and nothing that the county does or a municipality or the state does can contradict or violate the Constitution. The letter of intent submitted by the applicant, the conditional use permit itself, the conditions that were stated in that permit, all acknowledge that the way this was set up is that there would be no on-site dumping. Now, on-site dumping, according to the state regulations that I will get into in a minute in more detail, indicate that if you have a recreational facility, which consists of 2 or more recreational vehicles being placed in a public site, then you must have, you are required to have, it is mandatory that you have on-site dumping in at least one of 2 ways. Either you tie into a sewer system or you create your own on-site septic tank sewage type of system. Neither of those requirements was met by the CUP in this instance. Therefore, to start out, we must acknowledge, everybody in this room must acknowledge that the way this is set up violates the law. And in that sense, as Ms. Larson has raised the question, yes, there are at least 3 options here. One is to grant our appeal, deny the conditional use permit, if you will, and say, it's illegal. It should not be approved, and it must be denied. Another option, of course, is to remand We would recommend against that, but that is a middle ground. It at least would require the county to consider laws that should have been considered the first time around and that were not. Now, just to be clear, the regulations that I believe have been provided in the packet that you were given from the Utah Department of Health, I will say, require that the wastewater, it's 392-303-6, if you need the citation, require that the wastewater shall be discharged to a public sanitary sewer system, which again is one of two things, as I've explained to you. It also indicates that if there are any dependent RVs there, which can include tents, or even, as is stated in the rules and regulations proposed by the applicant, if you have a camper shell with no sewage facilities as a part of that camper shell, then state law further requires not just a public sewer system, but also requires that there be a service building. That service building has to have water supplied to it, has to have toilets, it has to have an ability to clean, to wash hands, and so on. That has not been provided either by the applicant in the letter of intent or in the CUP. Now, to go back for just a moment to what has been stated about state law and conflicting with a CUP or a county ordinance. The Utah Code that was quoted during the training, 17-27A-506, indicates that conditional use permits may not conflict with state or federal law, and this one does. The county ordinance, 17.06.050, capital B2B, further states or requires that the conditional use permit comply with the law. 17-27A-801, that was mentioned earlier in the training, further requires that a conditional use permit that is arbitrary and capricious or illegal should not be approved. And this one is illegal. The county ordinance states that a conditional use permit cannot be approved if it does not adequately provide for essential services. Those essential services obviously include water and sewer. And the conditional use permit here did not provide for that and did not provide for a potable water system. No requirements set forth in that. That would comply with the health regulations that I've previously referenced. Now, none of this should have been a surprise to anybody. During the presentation that you heard a few minutes ago, a list of public concerns were raised and put on the screen. No mention was made in that document a few minutes ago about sewer and water. In fact, sewer and water were raised by numerous people during the presentation. I was one who did that in one of my letters. I attempted to do that later in my presentation at the second hearing. Perhaps more importantly, a former RV park operator from Moab stood in opposition to the conditional use permit and stated that the sewage suggestion of having honey buckets drive up the road, how many times a week we don't know, to try to hook up to the individual RVs that are there and transport the discharge, the sewage out, is not something that should be permitted. He regarded it as, he noted that when he ran his RV, he had to have at a minimum a leach field. In fact, and this is critical, and it's crucial to your understanding of why we're here tonight, the commission, or the Planning Commission itself, raised this question during the first hearing. They asked if the Bear River Health Department had any input onto this decision. They were informed by staff that no, they had not been consulted, because if there is no on-site dumping, they have nothing to say about it. That was a false representation of the law. In fact, not having on-site dumping is against the law. A commissioner specifically asked staff to please contact the Bear River Health Department to see if they had anything to say. They did not. So the conditional use permit that was granted in this case was granted based upon a letter of intent that said that there would be no sewage disposal on site. The CUP agreed with that and made no effort to contact either the state or to contact the Bear River Health District to determine if there were any applicable rules or regulations that would impact the positioning of this RV park where it was under these conditions and circumstances. They did not follow through with what the commission itself suggested and with what is certainly required by the law itself. Now, I'd like to just briefly mention one point that has been a subject of discussion earlier tonight and was a subject of discussion during these hearings. And that is the granting of a conditional use permit mandatory? During the first hearing, it was stated that because the word shall is included in the ordinance and in the state law, it is mandatory. But that is not a complete statement of the law. If you look up these statutes, if you look at these ordinances, all of them indicate that it shall be granted if. There is a great big conditional if. And that's why it's called a conditional use permit. Conditional use permits cannot be granted or should not be granted if the reasonable measures to mitigate potential problems cannot be met. And here, what has been proposed, what was approved by the county, and what is now before you is something that cannot meet those standards. You cannot have an RV park with off-site dumping, with a honey bucket going up there to service up to 65 or 80, however many units are going to be up there, and there's different numbers in all the different documents. But it's not mandatory. It is conditional. And the suggestion to the commission that it was mandatory is yet again another misstatement of the law. Yes, there are some presumptions. There are some obstacles that must be overcome, but it must be noted that a conditional use permit is not mandatory, but is, as the name implies, conditional. At least one commissioner during the hearings stated, if staff tells us that what is proposed is legal, then I'm going to go along with that. Staff indicated that this was legal, and it was not. The commission was misled. You cannot be misled. It is clear from the presentation tonight, from the law that has been cited both in our appeal and in the response by staff, that the way this is postured is illegal and against the law. Due process, of course, is something that is, as we all recognize, something that is required by the Constitution. And I'm not going to deal with that at length because this process of dealing with conditional use permits is something that is prescribed in certain ways so as to limit public clamor, for example. And in many instances, the attempt to obtain a conditional use permit can go through that process smoothly and have no problems. But whereas here, the public first in letters, then in attempts to explain matters in the first hearing, and then in the second hearing, they granted a total of 15 minutes for rebuttal about what we had learned during that proceeding, even though staff had met with the applicant We didn't know what had gone on during those meetings. I attempted at that time to present legal arguments about why this was illegal, and I was told that I could present legal arguments in 3 minutes. Under these circumstances, where you have significant health, safety, and welfare issues at stake, and where issues are being argued in terms of law and in terms of facts that are understood or should be pursued by staff but weren't, then additional time should have been given. And in that sense, there was, to the public, a violation of due process. And I would simply note that the state laws pertaining to hearings by boards of adjustment, it expressly states that you are required to give participants due process of law. You've done that here tonight. We appreciate that. But we were not given that opportunity earlier. Lastly, the staff, as well as the Planning Commission, in this respect, are always to act as gatekeepers to determine whether something should or should not proceed. All of us here are familiar with irrigation ditches and the irrigation gates that allow water to go through or not go through. If that irrigation gate is welded open so that the water can always go through, there's no gatekeeper function that is being performed. Now, what the state or what the county has proposed here is fascinating. They acknowledge that this CUP, that this letter of intent violates state law, but they're asking you to deny our appeal and let them take a look at these illegalities at some future time. They want the water to just flow right on down that irrigation ditch, and they don't want any kind of irrigation gate blocking it, because at some point, either they, the state, Bear River Health District, somebody will take a look at it. I am asking you tonight to not do that, but to act also as gatekeepers and acknowledge that this violation of law should not be permitted to go forward. And I would now suggest that Mr. Stokes, who also represents the neighborhood group that's opposed to this, be allowed to speak with regard to whatever issues he has.
We're usually on a time frame here, and it's my understanding if we're going to go past it, I need to have a motion to continue.
Extend that meeting, yeah.
Extend the
I'll
meeting.
move to continue.
Is there a second?
How long would you like to continue the meeting for?
Yeah, it's open for discussion there. We can drag this on till midnight, I know we can. But we're not going to do that.
Do you want to?
Does 7:30 seem reasonable? Okay. And my motion is to extend to 7:30.
I'll second that.
Okay, all in favor, say aye.
Aye.
Okay.
Thank you.
Before you begin now, is there, I want to allow time both ways, and also the legal counsel as well. If there's something there that you think that we should be made aware of, we need to hear this. So I guess I'm just asking you to be as quick as you can as you do it, and then but
Sure.
I want both sides to.
Yeah, I will just clarify that when the conditional use application came in, staff sends it out to other parties for review, other authorities, and it was sent to the Bear River Health Department, and we had not received comments back from them. So we would have loved to have full understanding of those state rules. I think that during the hearing, or excuse me, the public review with the Planning Commission, had those been part of that review process, then the commission and staff would have formed conditions applicable to those. So
That time that they were informed that, were they informed that there will not be any dumping there, or was there going to be?
the
And that then tells them to get involved or not get involved.
It was just the proposal, the application for an RV campground was provided to Bear River Health Department. And for whatever reason, the comments had not come back. And we would have loved to have those. And so I just think that the review at the time, whether there's a review then, that missed opportunity or another opportunity to have it considered again with those standards, then that inconsistency, which we did cite, and I believe I mentioned that inconsistency termed by the appellant as a violation, but we think that there's opportunity to rectify that. And then, yeah, so I think that's the heart of it.
Okay, thank you.
I'm actually glad Mr. Watkins went and discussed that. We were told by the Bear River Health Department that they had no previous notice of this conditional use permit application, that there was an RV park coming. Like in the law where we're required to file a certificate of service that verifies that someone actually was given something. The other part of the evidence that contradicts what Mr. Watkins just said is the meeting minutes of the first meeting on December 2nd. The minutes are hour 3, minutes 7 through 10. In those specific minutes, 4 separate commissioners raised the concern whether the Bear River Health Department had been contacted and whether they had raised concerns about this RV park. 3 of them asked the question. Mr. Harold was discussing something with his staff and missed the question. Chair Spackman stopped the meeting, looked at Mr. Harold directly, and said, does the Bear River Health Department have a concern here? Have they been notified? What have they said? Mr. Harold's statement was no, because they aren't proposing on-site dumping, so there's no requirement to have them involved. Those were his exact words. So I would ask the board to make the assumption as to whether the Bear River Health Department was properly involved or not. Certainly when we spoke with them, they were discouraged that they hadn't been properly involved in the situation, and we were pointed to their mission statement and their strategic plan that talks about their desire to correlate with governing bodies, municipalities, and counties. We engage each other, our partners, and our people of Utah in decision-making, planning, and integrated effort. We strive to work effectively with others, to recognize the value and input of opinions gleaned from diverse populations and municipalities. The Bear River Health Department was deeply concerned about this, and they would have been had they received the notice from the county. Maybe it got lost in the mail. I don't know. But I know that we wouldn't be here today, and I'm pretty sure the applicant probably wouldn't have even brought it before the commission had someone just merely picked up the phone and called the Bear River Health Department and said, hey, we've got an RV park here. Do you guys have any concerns? Because as soon as they did find out about it, they said, yeah, we have a statute right on point that governs RV parks. So I hope that everyone here has learned something from this process. I certainly have. I gave a rousing speech that had 300 people applauding. Realized in hindsight it did me no good. I should have been specific. I should have been to the point. I should have hit these facts to the commissioners so they weren't confused. Because they were confused, not because of their lack of intelligence. Those people are very bright because they were hearing one thing from staff and one thing from the public and the policy that we were trying to bring to them. Ms. Larson brought up an amazing point that has been the overarching theme of this conditional use permit, is that the commissioners and most public authorities, when I go to public meetings, depend heavily on the staff reports. And this staff report was one-sided. It wanted to get this conditional use permit through because it thought that conditional use permits ought to be permitted in almost every circumstance. And it was said. There were several times that commissioners turned to staff and said, what do we do here? And every single comment was in favor of approval. One in specific that I would bring up is they were discussing whether to create roads and fences and other issues like that. And when asked, Director Harold said that the condition couldn't be too burdensome or too costly on the applicant. The statute doesn't say that anywhere. The statute says if it can't be reasonably done, then it should be denied. But if we have to use a burdensome or costly factor to mitigate an issue, then that's what we have to do. That's just how it works. Mr. Whitaker himself quoted Mr. Harold in the second meeting saying, I don't know if you can make me do a fence or a road. That's getting kind of in that too burdensome or too costly issue. And so that's how everyone was interpreting it. Obviously, me and Mr. Johnson have the luxury of litigation and knowing the law and knowing that not what everyone says is correct. And we had studied this issue deeply and came what we thought was very prepared. Again, in hindsight, I wish I would have taken a different approach, but here we are today. I wanted to take more of a technical approach to this. I've only dealt with appeals on 2 instances, one in the Ninth Circuit and one in the 10th Circuit. And I learned the hard way that if you don't know the record and the minutes, you're going to get yourself in trouble. So while Mr. Johnson is very a fluent speaker and transfers his message so well, I wish I had that skill. I dedicated this appeal to be more precise to the technical part of it and the minutes. So I went through the minutes with a fine-tooth comb. I listened to them several times. I looked at the whole record. So I'm just going to present some stuff on the record for you guys, just so you know where it was and why we're saying what we're saying, and that we're just not pulling this out of thin air. The first thing I wanted to do, though, I think it's pretty well accepted right now that the CUP is unlawful. I think the counties admitted it. Mr. Johnson, put a good presentation on why it doesn't comply with the law. I just want to read a statement from the Utah Court of Appeals from one of the leading decisions on conditional use permits. And it says, with regards to illegality and a permit being unlawful, a determination of illegality requires a determination that the decision violates a statute, an ordinance, or existing law, and therefore should be denied. The Utah Court of Appeals agrees with that position. Obviously, the statute from the Bear River Health Department, it's interesting, we went through these kind of glossy terms and hoping to fit a square peg into a round hole with the county statute that Mr. Watkins brought up, but the state put it all in a nice round hole for us all. And we could have just slid it in there had we had the statute, or not slid it in there, but we didn't. And part of the reason, again, is that the commission wanted it. They wanted to know if the Bear River Health Department had any authority here and if they could act. And they were told that no, they did not. I'm going to go to the minutes from December 2nd, where I've already quoted Mr. Harold or Herald? I'm not sure. Mr. Harold, is that how you say it?
I'm not going to correct you. Go ahead.
Okay. The minutes are on page 6 of 8. That's where whoever was taking the minutes says, Chris Sands stated his main concern is the lack of dump station on the site. Would consider requiring an on-site dump facility or a service truck to come and serve campers. Does the health department have a perspective on this? The minutes, which summarize what I quoted earlier from the exact minutes, which are 3 minutes 7 through 10, Harold responded that on-site dump was not an original CUP and that the Bear River Health Department has not been consulted about requirements for the dump station. So I find it hard to believe what Mr. Watkins is saying. The minutes say something completely different. The Bear River Health Department, I don't think, was properly notified, and had they been, I don't think we'd even be here tonight. I want to touch base on a few of the minutes as well. Minute 46 in hearing 2, Commissioner Spackman brings up deep concerns about the water rights and sewage. Minute 47, all commissioners seem to agree that on-site dumping will lessen the traffic and that it should be considered. Minute 106, Tom Johnson tells the commission in his basically 2.5 minutes that he was given that this violates state code, and then was cut off. Minute I'm going to say 141, meaning 1 hour and 41 minutes. Commissioner Parker states, if the staff tells me it's legal and it passes the statute, then I'm going to support the land use. Basically admitting that he was relying on the staff to know that it was legal or not, and now we know that it was not. I've already been through minutes 307 through 310 in the first meeting where the commission really wanted to know if the Bear River Health Department had a say here and was told that they didn't. Mr. Johnson spoke about Daryl Benson, the only person in this whole thing that knew anything about RVs We were all reading and hoping to learn. He was the only person that ran an RV park for 40 years in Moab, Utah. He said on 2 separate occasions in both hearings, this sewer system and water system doesn't work. It doesn't comply. Mr. Whitaker defended it in minute 116, saying that it did comply and that we had worked with Honey Bucket to resolve the issue. I don't want to drill on this too much, but the state code does not permit the commission to push forward a conditional use permit that is unlawful. The county code doesn't allow for it. It says it has to comply with the law. It can't be illegal. I don't want to blame people, and we all have to learn how to get better in our careers, and we all make mistakes, unfortunately. I'm the king of them. And I don't blame the staff for anything, but I hope we learn something going forward. I hope correlation, like the health department wants, I hope they'll get that call from the staff next time there's even a question, and then we don't have to go through all of this process to figure something out. And I need to do the same thing in my career. Before you file a motion, get on the phone with opposing counsel and talk to them. And it's been a learning experience for me from the very beginning. And I didn't think when this first conditional use permit application came out last year, as a neighbor in that area and now representing my neighborhood, that I would learn so much, but I did. And I appreciate your time. Thank you.
Any comment from the board?
Are we discussing, or you mean just questions?
Just questions, because I want to turn some time over to you two to tell your side, so to speak, inform us on things that maybe we need to know a little bit more about.
I would like to hear from Mr. Whitaker if he's here too.
You'll be given time, yes. But if you don't mind, I'd like to.
So, like we mentioned previously, my capacity here is counsel for the commission. So I just wanted to clarify a couple of things. So first off, when the code says that the conditional use permits have to comply with law, comply with the regulations and conditions specified in the code and other applicable agency standards for use. And we've been talking about the sewage issue. The conditional use permit for an RV park in the A10 zone is not per se illegal. It is permitted in that zone under county code. What we're talking about is whether or not this condition should have been imposed to comply with the health department rules to have this the sewage connection. So I just wanted to specify that the conditional use permit of an RV in the A10 zone, that's not illegal. That's not against state or county code. That we're just talking about a subset in this overarching issue. And the subset is the wastewater connection. And one of the conditions that was imposed to try and satisfy this concern, this anticipated concern of dumping on the site, the commission chose to impose this recommended either no dumping or honey bucket, which it turns out that the actual condition should have been that imposing a sewage connection to city sewage. So I just wanted to clarify that it's not that the use is illegal. It's not that the commission is making an illegal CUP for this situation. It's just that one of the conditions in this subset of conditions was maybe not the right fit. And secondly, it's been discussed the scope of the commission's decision-making power, and I just wanted to reiterate that the land shall is a powerful word in the law, and when it says a land use authority shall approve the conditional use if reasonable conditions are proposed that can mitigate those standards, then it must do it. Shall is a must. It must approve. And it goes on to say that mitigation does not mean elimination of the detrimental effects. So there's There was a lot of talk about traffic and of dust, and the commission's decision-making authority is significantly circumscribed, and they're not tasked with eliminating all detrimental effects, it's just mitigating. And finally, you know, the rule is that the commission is supposed to interpret and apply land use regulations in favor of the land use application unless it is plainly restricted under the law. And in this case, I think that the commission acted properly, and so I just wanted to clarify those couple of points about the commission's decision
I
making.
guess I'd like to clarify now though, because I'm really struggling with this. Was the Bear River Health contacted?
I would comment.
Somebody says yes, somebody says no, and that really makes the whole decision process on this.
I can,
I would, okay, I will comment on that. I think that it doesn't matter at this point. You know, whether they were contacted, they weren't, somebody lost it, it fell on the floor. I don't see that as material to our decision tonight. And I wouldn't ascribe any malevolence to it because we simply don't know what transpired. What is relevant is the law that has been discovered since the decision was made. And to my thinking, our decision turns on that issue. And to me, it seems that we either grant the appeal because the law was not complied with, or we remand with a directive to the Planning Commission that they consider the law that must be abided by and, you know, make their condition, or if they can't make the condition, then they can't grant a CUP.
Thank you very much,
But
appreciate
I
that.
think were they notified, weren't they? I don't even see that as material. I mean, it might be interesting history, but
It might be,
doesn't matter.
it might be just material now, but ultimately, that could have been the deciding factor on whether it was granted or not.
well, it would have provided more information, that's all.
Lisa,
So it would have provided more information.
Right, it might have provided more information, but your role is not, in the law, we call it a de novo review, where you get to open up every fact and look at them and consider all of that. That's not what you're doing. The law says that the appeal authority shall, 1, determine the correctness of the land use authority's interpretation and application of the plain meaning of the land use regulations. So that's the first thing you have to look at. And the other thing that you look at is, and interpret and apply a land use regulation to favor a land use application unless the land use regulation plainly restricts the land use application. That's really all you are looking at.
Okay.
And that's what you have to consider in your final decision.
and I guess the thing that I struggle with is they throw all this at us, and we're supposed to read all of this, and then how do we interpret what we're supposed to be passing judgment on?
Right, and that's what state law requires are those two things. That's what you have to make a decision on.
Thank you.
Will you say that one more time?
Yes.
You might need to do it, like, it takes 60 times for somebody to remember something.
Yeah,
But right now, I'd at least like it twice.
yeah, and I understand. I'm the same
Okay.
way. So,
oh, Lisa, would you maybe provide that reference and I'll throw it up on the screen? That might be
Sure.
helpful.
it is. Isaac, I can bring my copy over too.
But I know it's coming back to, and I appreciate what you said, I know it's coming back to exactly what she has said,
Yeah.
so.
So it's Utah code. Chris, you let me know when you're ready. Utah code 17-27A-707. And we're looking at subsection 4 when he gets it up.
Subsection 4?
Yep.
Okay.
He's zooming in on for it. So it says the appeal authority shall, A, determine the correctness of the land use authority's interpretation and application of the plain meaning of the land use regulations. And the second thing you have to do is interpret and apply a land use regulation to favor a land use application unless the land use regulation plainly restricts the land use application. Those are your two.
Sounds sort of circular.
Yeah, it
But
does.
it's basically saying it's permitted unless there's something, I mean, there's kind of an ideological difference. Some people will view everything as prohibited unless it's permitted, and some people will view everything as permitted unless it's prohibited. And this is the latter. That's what that's saying, is it's prohibited unless it's regulated or prohibited.
Yeah.
So the CUP provides a way to regulate it. So it is a permitted use, but it acknowledges that it might have an impact on the land that is more than what just an unregulated permitted use would be. And so it's the job of the Planning Commission then to come up with conditions that mitigate that make it softer, the impact not as great.
So you actually said it backwards. The land use regulations, you have to permit them, they're favored, unless there is a land use regulation that plainly restricts it. So, that's the only thing I was correcting, it was just, it was backwards.
But I think we're saying the same thing.
Yeah.
Okay, thank you. We're running out of time again, so we need to give you some time.
Can we just note for the appeal that there was no memo or anything filed by the appellee, and therefore we don't know what he's about to say?
Yep.
Understand.
I'm Nathan Whitaker. I'm the recipient of the conditional use permit, and I didn't know what to say until I heard what you guys had to say. So, a couple things to comment on. First of all, the state already prohibits no off-site dumping. And
So I think it would be excessive to grant the appeal, because even if it went forward, even if the conditional use permit was, continued to be pursued and the appeal was denied, there's already a governing, regulating body that wouldn't allow me to do any off-site dumping. So it'd be redundant. And I did want to give you a little bit of history. I learned of the Bear River Health Department's state code by myself because I was already getting bids on a public water system and the leach field. And Edge Excavation said, well, you should probably contact Richard Worley at the Bear River Health Department. And so I reached out to him because I wanted an idea of how big of a leach field am I going to need to service these many RV units. And it was at that time that he brought to my attention the state code. That's when I learned of it. We were initially looking at having Honey Bucket or some other service come and service the vehicle, probably out of concern to the residents in Smithville. The sense I got was they were concerned about the health and nature of having an on-site dumping facility that close to the community. I was trying to be sensitive to their concerns. Also, admittedly, that was also a less expensive approach. They referenced the RV camp manager who spoke previously. He did mention that
he didn't think it was possible to have a service truck and have a connection to hook up to each individual RV campground, but the RV recreational vehicle. But when I called and spoke with Honey Bucket, they said, oh yeah, we do that all the time. It's possible, we have the connection. He gave me what the charge would be, which I think was $175 to an individual recreational vehicle. So then I said, okay, well, and maybe this isn't relevant because it's not going to happen anyways, but he said that we could negotiate multiple RVs being serviced, and so it wouldn't come to $175 per RV owner. And so I was pursuing, reasonable options. Now I understand that you can't do off-site dumping. And I've already, several weeks ago, I've already moved forward to deal with that, to have a public water system and an on-site sewer system. So it's not even a question anymore. I'm planning on doing that. No big deal. I'm fine with it being added as a condition to the conditional use permit. And so I have no opposition to that. That's fine. So I don't see a reason for granting the appeal. It's already been argued by staff that the conditional use permit was granted legally. It's legal. If you do want to take the common ground approach to kick it back to the commission so that they can add it as a condition on my conditional use permit, I'm very comfortable with that too. It just gives me additional time to meet all the conditions. So I'm not opposed to that. There was reference to the staff perhaps being easy on me, trying to push this through, that a fence, there was discussion from the commission about having a fence or a road. The discussion wasn't so much whether or not I would be obligated to have a fence or a road, but the discussion was what that fence would entail. What is the purpose of the fence? Does it need to be, a fence that is thousands and thousands of dollars? Does it need to encase the RV campers in the RV campground? Or do we just need to have a fence to demonstrate what the border is? And so the discussion was, what is the purpose of the condition, and what is the reasonable requirement of that condition? In reference to the road, it wasn't whether or not I should have a road in the campground. It was whether or not it should be paved, or whether or not it should be gravel, and there's material sprayed on the road so it prevents kicking up the dust. That was the biggest concern that we were addressing, was to limit dust. It was also raised that I may be allowing campers in tents to stay or vehicles to stay. That's not the case. It states specifically in the RV campground rules that you have to stay in a recreational vehicle that has electrical, sewer, and water hookup. That's in rules. And so there would be no dependent campers, which means I would not be obligated to have a facility with a bathroom and running water. I wanted to be clear about that. That is all that I have in response to the comments. Is there any questions for me? Yeah.
So you'd mentioned or it was noted in the outline that we received that you're looking to have pickleball courts and horseshoes and potential day use. So where would they be provided services? Or do they only get to come in if they are with someone using a recreational vehicle?
Yeah, that's a great question that I haven't thought through yet. To remain compliant, I think they would have to have a relationship with somebody there. Would the code require that a visitor have access to bathroom facilities? I don't know the answer to that. If it does, then I'll address it so I remain compliant.
Good question. Any other questions?
We're gonna have to extend again.
Yes, we are. And this is the last time.
Okay, I'll move that we extend to 7:45.
Second?
I'll second that.
Okay, all in favor?
Aye.
Okay. All right. Thank you. I guess I'd just like to open it up to the board. Is there any discussion or any questions you might have?
I like the fact that Mr. Whitaker's already addressed a lot of the concerns that were a part of the conditional use permit, and that he's not trying to thwart them, he's actually trying to make it work.
Yeah, I think it's appropriate it gets cleaned up, though. I mean, my thinking is we remand it with a directive to apply the law that was not considered in the decision of the Planning Commission. And I'd have them put that in there because, you know, Mr. Whitaker might want to retire to Alaska or something and sell it, and whoever acquires it, they need to have the right conditions since they will run with the land.
And I know we've been talking about just the sewage problem and the water problem and that. There are some other issues that was brought up there, and that's food for thought, but I have my business on a gravel road, and I'm telling you that retardant doesn't work for very many days, and I have a dairy operation, and my baby calves choke all summer long because of the dust. And it is a legitimate problem. And it could really be when you get 65 of them in there.
Is
That's
that
just food for
issue
thought.
on appeal?
No, I said it's food for thought.
Yeah, sure.
It's, if I might just say, it is brought up in the appeal as to.
Whatever your point of order should be, if you're going to allow additional discussion, you should be specific and intentional with that, and they should come to the mic to address it.
I'd be about 90 or maybe 60 seconds.
So the nature of that, you mentioned in the appeal is, I guess is our beef with kind of the instruction that the commissioners were given. The way I saw it unfold was kind of like a judge in a jury trial. The jury asked for direction. The judge gave them improper direction, and the verdict was wrong. The appellate court said, that direction was wrong, so you're gonna have to redo this. And so when we got on the discussion of all these other issues, the reason the commission said, we better just go with gravel, if you go back and watch all of the minutes, I think you'll agree with me, was because they felt like their instruction from the staff was that it couldn't cost too much. And so every time Mr. Whitaker said, I don't like that that's gonna cost too much, they caved on the condition they were going to give. So if this is remanded, I would hope that it's remanded with both the instruction to apply the statute and the instruction to the commission that the cost of the mitigation that would make it so it's no longer a reasonable detriment is not relevant. If you can't get to reasonable mitigation by an uncostly condition, then you didn't get there. And so I think that if it is going to be remanded, that there ought to be also an instruction to disregard that idea that you can't put an expensive condition on Mr. Whitaker merely because it's expensive, you have to do it if it's the only thing that will mitigate the condition. That's why there was never a paved road, because Mr. Whitaker knew that this was less expensive, and the staff told the commissioners that this couldn't get too burdensome. And I assure you, if you watch all 6 hours of it, you'll agree with my position.
Council, are you familiar with the Nolan-Dolan test and rough proportionality? You're comfortable to address that? I think there's a misunderstanding of what that is.
So I just wanted to reiterate what the standard is for mitigation. The requirement to reasonably mitigate does not require elimination. So the concern, as I recall, was dust arising from a road, and the condition proposed to mitigate that problem, not eliminate it, was this spraying on the surface. And so an instruction to the commission to enforce a different condition to eliminate that would
It's none of our business.
it could exceed what is required under the code, as mitigation does not equal elimination. That's all I wanted to say.
And perhaps I point to that just to say those so that the appellant can consider those tests and maybe answer the question themselves.
If I may just add on page 3 of the staff memo, it's in reference 1, and the third paragraph down states that the commission's focus was on specific to this road issue, the commission's focus was on a sufficient level of mitigation to reasonably mitigate impacts. For example, condition 5 provides options to the applicant to reduce dust from a proposed interior roadway by stating that in order to reduce dust, the interior roads must consist of a gravel surface treated with dust-reducing spray, such as magnesium chloride pavement or similar material that reduces dust from the interior roadway. So the measure is there adequate and reasonable reduction of dust? And if one spray doesn't handle it, then pavement could be required.
Who determines that?
Pardon me?
Who determines that? If it's not doing a job?
We may not have time to discuss that now.
Complaints, yeah.
From the neighbors, come back to
Food for
the,
thought again.
Yep.
Thank you very much.
No, there's a standard. What it is here's the standard, keep the dust down. And however you have to do that, do that. But that's the standard, is keep the dust down.
If they fail to meet their condition,
Yeah, go ahead, sorry.
if they fail to meet a condition of approval, that's grounds to revoke the permit, and it goes back to the commission. So there's a process built in to accommodate that issue.
1 minute, please.
Less than that. In our appeal document, we raised the fence issue, we raised the dust issue, we raised the gun range issue. We think that if it's going to be remanded, then the commission needs to consider everything that might have an impact on this. Thank you.
Thank you, Mr. Whitaker.
Approach the mic.
Run. No.
Yeah, in reference to the dust, campers aren't going to want to stay there if there's dust kicking around and flying everywhere. So there's going to be detriment to the campers staying there before it becomes a problem to neighbors who live hundreds of feet away. So I'm a physician. I'm also going to be interested in those who are staying there at the campground. I'm going to make sure that dust isn't an issue. Thank you.
Business. Are you a respiratory therapist? Kidding.
I'm done with the ER.
Off the record. Off the record.
I'm retired.
Quickly.
My name is Clayton Housley. I'm a neighbor of this, the proposed site. I do want to point out that though you have great intentions, the CUP doesn't belong to you. It runs with the land. And you have a right to sell that, right? Correct? Okay. I'm curious, Mr. Hurd, you mentioned that there is a process in place if something's not complied with. As a citizen who might be impacted by that, can you describe that process to me?
I can give you an example. The most recent complaint I'd received, so the county's fairly large, we don't track everything. So as a complaint will come into the office, I'll go investigate that myself. I'll go out, take a picture of what's happening, and I contact the property owner to confirm that what's happening is what I think it is. If they fail to respond, I send them an initial notice of violation, which states what the issue is specific to that violation. In the case of a conditional use permit, if they are not complying with the conditions of their permit, I do the similar thing. I contact them. We discuss what the issue is. If they do not work to come into compliance with that condition, that is forwarded to the County Planning Commission to revoke that permit. There are specific rules attached to how those permits can be revoked. I can point to that section of code. I think, what's the one we have right now? The Holyoke Airport is currently an item that's been considered. That'll be up at our next meeting. It's under review for revocation. So if you want to see how that's handled at the next meeting, you're welcome to attend the Planning Commission meeting this next month. But that's the process that's pursued. Granted, the disadvantage for this is I don't have time to drive around the county. So there really is a concern that's valid to say, well, how do we keep track of all these violations? We have the same concern. We requested funds from the council, and they've admitted or allowed us to have funds to hire an enforcement officer. So we're recognizing the need there to do the follow-up and track down those things in the county that are really kind of egregious issues. But that would be the process you pursue. You contact our office, to restate. You contact our office, and then we do an investigation and a follow-up to confirm it. We encourage folks who are pursuing these complaints to just check back with our office for updates as they feel that appropriate. We don't give reports back to the complainants. Our hope, like the last one I saw, was a bunch of people were collecting stuff, as happens in the county. It happens in the county. I contacted them. They were very compliant. They removed all the material. The neighbor contacted within so many days and said, thank you for contacting them. This is much better. So there are successes, and we also have challenges. But long story short, that's the process.
So just to confirm my understanding, I don't call the sheriff. I should call you. Thank you.
Thank you very much.
Thanks, that's helpful.
It is. Well, board, I've got the cattle prod, so.
Well,
What you want to say?
Go ahead.
Well, I would like to pursue, I think it needs to be reprimanded, but remanded back with the stipulations. And what you said is how I feel. I just can't say it.
What'd I say?
Oh, we can go
It's
back
been a
about
while.
Previously.
13 minutes ago.
So I'll repeat what I think I would have said. I think the core issue is the legal issue.
Yeah.
That there was a point of law that was not understood when they made their decision, and I think it needs to be remanded for that. As for the other issues, they're a little more subjective and discretionary, and I don't see those as compelling. I think we could invite them to make sure that they feel comfortable with the decision, but I don't know, that kind of troubles me a little bit.
Yeah.
The most clear-cut issue is that there's a matter of law that was not understood when they made the decision.
The state law.
And all the other stuff, I mean, you can learn from it and try to do better with communication, but I don't see that as relevant.
It's not relevant outside of, in my opinion, and I appreciate you talked about heated discussion in meetings before and the letter apologizing and that, I mean, we got all that and I read that and that, I think there's good communication. I feel there is between you and all of you. And so with that being said, let's all get along. In other words, I think to make this right with neighbors and everyone, work out all the little details, okay? Just talk about them. Because I feel Mr. Whitaker seems to be wanting to comply. So that's what I want to say.
I was gonna say, I looking at it, I think that the county probably, or the staff was thinking that that's kind of in a catch-all, if I'm understanding right, that even though they missed something, in that catch-all, the state code pops up and here it is, and now we take care of that. But I do think it would be best to have all that up front by remanding it back to the planning commission. But I do think that what I notice is there's nothing in here about the potable water part either, in either the camping's rules and or as a condition. And I think that's almost as important as the wastewater. I think you're looking at the water also. So I think we have to probably give, I don't know if it's the right terminology, but some direction to the planning commission to look at all of the issues or all of the conditions that they already put on and make sure they're completely mitigated. Because there's nothing in there about water, and you abut Smithfield City. I don't know where the water ends. It may be 4,000 feet away or 3,000, 2,000 feet away.
It's like 150 feet away, but they refuse to allow me to connect. So I already have a water well dug.
Okay.
I have my
So,
water
so if you're
well.
100 feet away with water, you're 100 feet away with sewer.
Sewer, yep.
So the problem is inside the municipality, it's, short-term campground is not
And this is
allowed.
county.
Yeah,
Right.
this is
So-
because it's outside
Right.
the city.
They don't
But-
provide service, unless you annex.
Unless you would annex, right.
Generally, they don't.
The only thing is I mean, if they're not interested in annexing this, because you're that close, that's what I looked at, was there's there's a 40-acre parcel that, so depending on where the utilities are, but if they're not interested in bringing you under their umbrella, I think you need to be able to supply potable water, meeting all the state codes from the Division of Drinking Water, and then meeting
It
all the
sounds like
wastewater.
you're approaching
Yeah,
to do
and you're
just
getting
that.
there, yeah.
But,
But I do think remanding it back gives, with some direction, so that the planning commission actually looks at each of the, if you look in the packet we had, each of their conditions, they might want to add water, because wastewater was talked about, but water's not in there, and I can think that's just as important as wastewater in there, so that's just my take on it.
In fact, the state code requires a public water system for that many campers.
Yeah, I was gonna say for your 65 campers, yeah, you'd be, yeah.
Okay, so the motion would be,
who wants to do the motion?
Do we need to motion to extend as we, I don't know, just.
Let's just wrap it up and be
Okay,
done.
that works for me. My one thought was, like I mentioned before, if there are going to be, if it is gonna be open for public day use, which I noticed that it was, I think, public facilities really ought to be considered. That it may, and unless there's a way to really make it so that they are specifically with a guest, which I think will be tricky to do. That's just a thought.
But I guess that's really not something that we're,
Well, so,
I mean, we're not the planning
right,
commission.
Right,
that's what
but
I'm
that-
saying. Yeah.
So we're addressing, issues.
But we could recommend, we
So
could pass
We could,
recommendations.
recommend it.
so I'd put a motion out there that we remand it back to the planning commission with them, or I'm not sure how to word this exactly, but have them look at all the conditions. Not only all the conditions that are currently on the one we're remanding back, but any others that now come to light through the state code as they interpret the state code from the Division of Drinking Water and wastewater connected to that.
I'll second that motion.
Yeah, so
That-
just for clarification, go ahead, you might.
Consistent with recommended, read that, see if that's consistent, if what you're saying is consistent with what this language is.
On
What
Which
page?
is- Which is
page
not
3
to
or-
say that it.
It's on the back
has
page
to.
of that.
Yeah, it's the
8.
back, it's the last thing on the back.
It's on 8.
And you can tweak that, it might help with.
It's
language.
just with language, if that's.
Well, I'd probably tweak that a little bit, because I think it needs, so this, we're talking, it says remand it back to the planning commission to address the inconsistencies with the CUP condition and the state administrative rules applicable to recreational vehicle park sanitation.
I point to that as a reference, like Ms. Larson said, it just
Yeah.
clarifies what you intend.
Right, but I think I think we need to remand it back and have them look at any other ones that they may have missed as they look at that overall.
To the extent that the newly uncovered law
Yes,
prescribes what they
Yes.
need to do.
yes.
Because otherwise, you're just saying,
No.
just start the whole process.
No, not start the whole process over, because if you, so, I'm not 100% if 392, 301 addresses the potable water and the sewer, or is it just 301, the sewage?
So I
Treatment.
want to point you again to that's what your job is. And so where you can't reopen it up for everything, that's not what you're doing.
No,
You're only supposed to look at, unless there's a land use regulation that plainly restricts what was done, that's all. So it, like she's saying with the one law that's missing, you,
Which is the on-site
which is the on-site,
yes.
sanitation.
but coupled in that somewhere is the potable water, because if you read the whole code that came to us, was that all 301?
And the facilities.
Service facility, potable water, they're in,
They were all in the same, they were all on the same thing as 301. Yeah, 301, yeah, because, 301-5 is the potable water, yeah.
Mine's all on my laptop.
So that 392, so, yep, that would work. We could read,
If we reference the code
we could
section
reference the code then, because that
and
covers
make
in
sure
the,
that the conditions
Yeah.
comply with the
yes.
code section.
So I'd amend my motion to
That
cover that.
way, that's the main issue, is
Yeah.
that code gets applied to the conditions prescribed in the CUP.
So I'd amend my motion then to reflect that it fall under the 392-301.
Okay.
Yep.
Any other comment, discussion? If not,
Did you get all
we'll,
that? Chris?
I almost feel like it's what I already wrote, so you might need to clarify for me if there is a difference between what
No,
you said
that-
and what was written.
we just found out that it wasn't, so whatever you wrote there
Yeah.
is right on the money.
Yep, yep. If you reference the number 2 on the last page, fits that.
Yeah.
Just to clarify, it sounds like you're saying that any and all issues related to that.
To that,
To that.
That
yes,
code
to that
section,
statute.
because that's
Rather
what
than
was
Just the
missing.
state code.
Right.
Yes,
exactly.
rather
And
than
I
just-
like the language should say that, but I'm just recommending.
That's what it needs to state, not just like pinpoint to the sewage part, which might be 301-7, all of 301.
So anything related to that.
Does that make sense?
Yeah, absolutely.
All right,
Because that's what was missing from the decision,
at the beginning,
right?
yep.
So, just exactly what you said there.
so we have a motion on the floor, is there a second?
I'll second it.
A second, moved and seconded, all in favor say aye.
Aye.
Okay, I want to personally thank all parties for the respect you showed to each other. Let's get along. Life is good when you do, so, thank you very much. Move to, have a motion to adjourn,
I moved the motion to adjourn.
I'll second that.
all in favor say aye.
It's-
Second, third, and fourth, and fifth.
Yeah.
How far down this road?
I'll tell you what, we need to either meet more often or quit.
Yeah, no kidding.
Just pack it and then I go.
Man, I've been reading for 2 months. Like I opened up my door, they said it was coming, I kept saying to my wife, I got something coming. It's gonna be door delivered, and so anyway, I finally opened it up last night.
Thank you.
Man, I just started crying on it, and I just, I'm like, anyway.
That's how one was.
Okay,
I told Hal, I said,
so for your decision to be final, we have to issue a written decision.
I didn't have to.
So. Have to contact
Oh, okay.
Because I'm happy to draft it to how, what your motion was. I've got that written down.
But yes, thank you, sir.
And then issue it to you guys to make sure it's all one.
Gotta,
So to make your decision final, you have to within the next 15 days. So I'm happy to draft it and to send it to you guys to review and just double check. But I need all of your contact information.
So you need our email.
Yeah, basically.
that'd be great.
Yep, we'll write it down.
Oh,
Chris had some.
Yeah, there we go. The official.
So if you guys could just
Defend. That's false, But,
yeah,
whatever that
send an email back.
I give a
Okay, well.